Further hearing in the appeal to Queen of applications DA and DS and others against Secretary of State for Work and Pensions.
Yes, Mr. Travel. Good morning.
Good evening, my lords. I have a couple of matters from the clip that I need to go through before I come to some solutions on the proper characterisation of the discrimination involved, and then some, I hope, short submissions on issues such as status, ambit of Article 8, and the approach to the relevance of Article 3. Finally coming on to remedy, hopefully fairly shortly, but obviously important. So, can I deal first of all with the references to conditionality and sanctions, which is page 8 of our clip. And your ladyship and my lord should have, provided by Miss Leventhal today, a sheet of paper, because I was conscious when opening the case yesterday that I dealt with conditionality and sanctions by reference to Miss Garnham's witness statement rather than the statutory material. Frankly, that was because I couldn't find the statutory material, but we've now located it. I'm not proposing to go through it now, but I hope that you have, paragraph by paragraph in Miss Leventhal's note, a reference to the principal primary legislation, for example, the Job Seekers Act 1995, and the regulations made under it, together, regulation by regulation, with the provisions that Ms Garnham refers to.
Is this contentious?
My lady, we don't have a copy of this note.
Well, it would be good if you did.
Thank you.
Because if you could reassure us that you accept its accuracy, then we've not got so much work to do.
If we assume for the purposes of today that it is accurate,
Yes.
and we'll let you know if we have any issues.
Thank you. Yes. That's a fair assumption to make.
So going back to page 8 of the clip, we deal with this issue in paragraphs 27 to 36 of our printed case, which the court will find in the core volume, obviously, at MS 8304. I think I took the court to a bird's eye view of this yesterday anyway, but let me just make the specific submissions. Paragraphs 27 to 31 set out the framework, which is now backed up by the statutory references into this morning's note. We make a specific submission in relation to in paragraph 32 about the double effect of loan-on-loan parents, of a combination of the benefits cap scheme, which is said to pursue a work incentivisation aim, together with sanctions. So as we say in paragraph 32, the obvious point is that the practical effect is that the sanctions imposed under the conditionality regime are imposed in addition to the revised cap, i.e. a person who's had their benefits reduced under the revised cap for not being in work, which is our characterisation of the effect of the cap, but in any event, you can only avoid the cap by actually finding work. That's the point. Will have them further reduced if they fail to comply with the conditions. So what we describe as two sets of sanctions are certainly two different effects, which is a major financial loss under the cap if they're not actually in work, a matter at least partly out of their control, and a further sanction if they fail to comply with whatever conditions under income support or job seekers allowance which apply to them. And the remainder of paragraph 32 draws attention to the contrast with a single claimant. And then over the page, well then at the foot of page 8305, paragraph 33, set out a paragraph of Miss Garnham, which I did take the court to yesterday, and then we deliver what Lord Carmouth wanted to know, which is what is the government's response to that characterisation of the scheme, by setting out in paragraph 34, paragraph 19 of Mr. Edson's second witness statement. And the court can read that. And the first 4 or 5 lines say, however, that contention, that's Miss Garnham's contention, misunderstands the policy intention, namely that the benefit cap is complementary to and not a replacement for the conditionality regime. Whilst the conditionality rules require certain claimants to look for work as a condition of receiving full benefit, the benefit cap is intended to encourage claimants into work where they can. This is not a purely semantic distinction. And then your ladyship and my lords can see what he goes on to say. And he ends up by saying halfway down the paragraph, a system of conditionality makes clear what is expected of them in return for the support they receive. Conditionality is relaxed or suspended in relation to certain groups of claimants where work-related activity is not reasonable in their circumstances. This does not mean that government does not want to support them into work where they can or believes it impossible for them to work, but indeed it incentivises them to do so insofar as they're able to, thereby instilling a mindset that work is the default. Then we make the submission in paragraph 35 that the court can see that he doesn't deny the proposition that the benefit system already provides a strong incentive for lone parents to find work, nor does he deny it's implicit in the calibrated and tiered system that the system recognises it is harder for lone parents, and especially lone parents with younger children, to work, or to work at a level sufficient to escape the revised cap. And indeed he asserts the system of conditionality makes clear what is expected of lone parents in relation to work, and recognises the relaxation of conditionality reflects that work-related activity, and therefore presumably actual work is not reasonable in their circumstances. That's the key submission. The whole structure envisages that there will be substantial numbers of lone parents for whom work is not actually going to be a practical reality for one reason or another. We've seen the crude figures. 95% do not move off the cap into work because of the cap. Sometimes they would have moved anyway. We have a structure, a carefully calibrated structure, which recognises that there will be quite a lot of situations in which the lone parent will not actually find work, hence the absence of conditionality or sanction in their case. And so the submission is, in paragraph 36, the reality is that the revised cap directly cuts across the more nuanced, but by no means lax, conditionality and sanctions regime, both by imposing a sanction for not working that is inconsistent with the recognition elsewhere that it's not reasonable to expect lone parents with young children to work, and that lone parents with older children are more limited than other claimants in their ability to work, and B, by actually imposing a sanction on lone parents is additional to more onerous and harder to comply with than that imposed on other benefit claimants not subject to the cap. And so we make the submission that's in the remainder of paragraph 96. And we stand by that. Now, going back, I don't propose to take the court to any of the other references to conditionality that are set out on page 8 of the clip. Mr. Ward, in his latest witness statement, as you will see from the last, from the 2 bullet points in the middle of page 8, Mr. Ward's recent witness statement promises further clarity on the relationship between conditionality and the sanctions conditionality regime. Our short point is that it doesn't produce any further clarity at all. It simply repeats the same point, including the point in the penultimate bullet point, that sanctions are applied to benefits claimants, are entitled to, presumably, for those affected by the benefit cap. It's this amount that's reduced further to ensure claimants experience a consequence of a failure to meet an agreed requirement and affirm that claimants are responsible for the consequences of their actions or inactions. So one is left with a position that a financial detriment, to use as neutral a word as I can find to describe the cap, is being imposed on lone parents in circumstances where the rest of the regime recognises that they may not be able to find work despite their efforts to keep up with the job seekers agreement or whatever it is that's in the relevant part of the conditionality regime that they're dealing with. So those are our submissions on conditionality. The other, page 9 and then through to 10 and 11 of the clip deal with childcare. Once again, in the interests of timing, I'm not going to take the court to all these references, but they are a very important part of our case. They're part of the reason why it is that the conditionality regime that we've just been discussing doesn't impose penalties on people who are not actually working. It simply encourages them, I say encourages, it imposes penalties on them for not attending work interviews, making efforts to find work and so on. But it doesn't actually impose a detriment for not working. One of the reasons for that is no doubt the practical recognition of the difficulties of people with children under 2 or under 5, depending on which group we're talking about, or more generally, and we make the more general case, finding work given the pattern of childcare that's available. The evidence shows that this diminishes in importance as the child reaches primary school age of 5. But it's an important point all the way through. So the references are important. I draw particular attention to paragraph 2, which gives the court references to the particular practical experiences of my 2 clients, lay clients. And I invite the court to read them. They are accounts of people doing their best to obtain further training, to work towards a future career, and so on, in a way that one would expect, but not actually, in a given week, given the age of the children, working, because that's, for the reasons explained in the evidence, not a practical possibility. And if I just give the court one further flavour, if the third bullet point in paragraph 1 of the note, page 9, refers to Miss Garnham's witness statement, and paragraphs 96 to 98, just some of the thinking behind it. The court picks up the core volume, so it's the same volume as the printed case, which we have open already, and looks at MS 6551, so in our appendix 1, and there's a trio of paragraphs 96 to 98, which discusses the practical difficulties with finding childcare in a way which will actually ensure work, because it's actual working that will get you off the cap. Anything less won't do. And I simply draw attention to those paragraphs. We'll see what, no doubt, Mr. Sholden will take you to what the government says about all this, but the bottom line comes back to the proposition that there are substantial numbers of lone parents who cannot, for perfectly reasonable, understandable reasons, actually find work, or actually work. And we've detailed that. Miss Garnham's witness statement refers in the first sentence of paragraph 96 to Miss Broom's witness statement from the Family and Childcare Trust, and the clip gives the court the references to that. So all of that, we say, reflects an important practical reality, which is that the large number of lone parents being caught by the cap are precisely the people who are going to find it most difficult to actually move into work in any given week. And members of the court in SG or JS, whatever one calls it, reflect.
Let's call it SG.
I'll stay with SG. The report is very confusing because it starts off with SG on the front page. And but anyway, stay with SG. But anyway, it's the practical reality recognised by the court. And in its paragraphs 201 and 202 of Baroness Hale's judgment. So the last point from the clip is the page 12, best interests of children. The issue here I would characterise as being whether the conclusions reached by 3 members of the court as to whether or not the original cap satisfied Article 3 of the UNCRC apply to the revised cap. In order to complete that exercise, we have given what we hope is a comprehensive set of references, first of all in the impact assessment and the equality analysis amendment regulations assessment, equality analysis for the amendment regulations, so one can judge whether that's true or not. If I can go to SG just shortly to indicate what it was that members of the court thought was the problem with the government's consideration of the cap, SG being in Core Authorities Volume 2, Tab 16, starting at MS 335. And if we can go, first of all, to the judgment of Baroness Hale, paragraphs 225 and 226, MS 401, both paragraphs are obviously relevant, but if I can just read 226, government's contention was the long-term shift in welfare culture, or reversing the impact of benefit dependency on families and children, would be beneficial to children in the longer run. This may well be so, although it's interesting how little prominence was given to this aspect of the policy and the justifications put forward by government for their policy. But in any event, this is to misunderstand what Article 3.1 of the UNCRC requires. It requires the first consideration is given to the best interests, not only of children in general, but also of the particular child or children directly affected by the decision in question. It cannot possibly be in the best interests of children affected by the cap to deprive them of the means to provide them with adequate food, clothing, warmth and housing, the basic necessities of life. It's not enough that children in general, now or in the future, may benefit by a shift in welfare culture, insofar as the Secretary of State relies on this as an answer to Article 3.1, he has misdirected himself. Now, that point, which I know some of the members of the Court thought mischaracterised the problem about the reference to adequate food, clothing, warmth, and so on, but it ties in with what Lord Carnworth says, and as I understand it, it's a reference to the basic idea that the benefit system, without the cap, works by reference to applicable amounts and to specific child-related benefits, such as child benefit and CTC, child tax credit, which are the benefits which are designed to provide a basic, reasonable standard of living. That's what the idea is. And so that the cap works by taking you out of that system and putting you on a lower level. And if we go to what Lord Carnworth said, we will find that at paragraphs 122 to 128, MS 373, and the whole passage is relevant, obviously. But in paragraph 122, Lord Carnworth picks up Lord Hodges' summary of the relevant principle in Zombas and says, just at letter C in 122, I would emphasise the first and last at paragraph 10, the best interest of the child an integral part of the proportionality assessment under Article 8 of the Convention. 7, a child must not be blamed for matters which he or she is not responsible, such as the conduct of a parent. It goes on to say there may be circumstances where the weight of another primary consideration can tip the balance. And then the Lord says in paragraphs 1, 2, 3 that this can all be solved by looking at what Mr. Holmes said rather than trawling through parliamentary material. And then in 1, 2, 4 makes the point which we strongly rely on. The difficulty with that response in the context of a duty to treat the best interests of the child as a primary consideration is that it ignores the distinctive statutory purpose of the child-related benefits. Lord Reid refers to the ministerial response in the course of the parliamentary debate to the effect that working people on low incomes had to cope with difficult circumstances and live within their means, and the earnings were not determined by the size of their families. Government believed the same principle should apply to the level of the cap. As applied to child-related benefits, in my view, this was a false comparison. The benefits are paid regardless of whether their parents are in work or not. In this respect, therefore, workers and non-workers alike, before the cap, were able to rely on this extra assistance in coping with difficult circumstances. Although paid to parents, the benefits are designed to meet the needs of children considered as individual. There was a reference to what Baroness Hale said in Humphreys, and at 126, a reference to the submission that CPAG was making, which is the cap was a complete innovation in the combined benefits and tax system. And then 127 is an important paragraph, both for present purposes and also for the submissions I want to make, very short submissions I want to make on remedy. It's the point about emasculation. So in 127, Lord Carnworth says, Lord Reid has referred to statements made to Parliament in November 2011 that excluding both child benefit and child tax credit would reduce the savings from the scheme by 80 to 90%, and so emasculate the scheme. Not clear whether these are up-to-date estimates nor how they relate to the regulations as opposed to the bill. If correct, they raise the questions why the viability of a scheme whose avowed purpose is directed at the parents, not their children, is so disproportionately dependent on child-related benefits. nothing in Mr. Holmes's evidence which addresses or answers these questions. Now, when we come to remedy in this case, one solution will be a declaration which simply said there was a breach, the application of the cap to lone parents breaches the convention rights by the lone parent or the child of lone parent, depending on where we get to with the debate on status.
Does that, I mean, I remember being rather puzzled by all this. Does that apply also to the present scheme? And
Well,
is there a response to it?
That in a way is the subject matter of the clip.
Yes.
The difference, there is a difference which makes my task one more stage more difficult on remedy, which is that the list of benefits was fixed by regulations in the original cap and is now set out benefit by benefit on the face of section 96. So one can't simply, consistently with the primary legislation, shift the child-related benefits out. So the acute question for the court becomes, well, if you can't do that, and the impact of the cap on the child-related benefits and lone parents or children of lone parents, assuming they have a sufficient status for Article 8 purposes, is a breach, what does the court do? And my submission is that it declares that that is the effect. Now, that will have an effect on the efficacy of the policy, obviously. But
I mean, do we have figures as to, I mean, that it was the 80 to 90% figure, which I find. Do we have comparable figures now as to what extent efficacy of the present scheme is dependent on child benefits?
Well, even at the time of that judgment, there were more up-to-date figures, which I gave in paragraph 77. Presumably there are more up-to-date ones still by now.
I'm sure there are. I hear the question. I'll try and find the answer. But we know, I mean, the very crude picture in terms of the impact on lone parents is that the cap, the working of the cap as a policy appears to be, is heavily dependent on its impact on lone parents. I took the court to the relevant paragraphs in our printed case yesterday. I know this is a slightly different point from the quantum of child benefits. But the statistics are set out in paragraph, the statistics of the impact on various groups are set out in paragraphs 51 and 52 of our printed case at MS 8312. Right. Miss Leventhal is telling me that in Mr. Ward's evidence, which is in the supplementary bundle at MS 9835, this is not quite my Lord's point, but paragraph 43 is saying for better or for worse from my perspective in terms of fashioning the remedy, that exempting lone parents from the cap would have a drastic impact on the policy overall by removing nearly 3/4 of the caseload. Exempting lone parents with a youngest child aged under 5 would similarly remove over half of the current caseload. Even the smaller exemptions sought by the appellants in DA would significantly undermine the efficacy of the cap by removing almost 1/4 of the households from the caseload. So that's not the same as answering the question about child benefits, I appreciate. But the corollary...
Well, it would, I mean, that's just obvious, isn't it?
Yes, I completely agree.
Absolutely obvious. It all depends what you mean by efficacy. It certainly undermine the impact.
Yes.
And save the government less money.
Of the sort of order that we saw in the note we put in yesterday, taken as a whole.
Yes.
I mean, the essential merits of my case are that you have a cap which in fact works by affecting far more lone parents than anybody else. And it is precisely the lone parents, for all the reasons that I've been putting forward this morning, who find it most difficult to comply with the work incentivisation policy objective of the cap. That's the fundamental problem. It's a fundamental problem that was played around with sounds pejorative, but it was the subject matter of SG. So, going back to does the consideration of best interests in the revised cap meet the problems that were created, that were identified by members of the court in relation to the original cap? We say the firm answer is no. We plainly do have in the references on page 12 a reference to the desirability of children being in households where there was somebody working. And it's not part of my case to say that that idea is misconceived. But what you won't find in the references, which we've just given, is any consideration or identification of the impact of the withdrawal of part of the subsistence benefit scheme, in particular the child-related benefits, on the children who are going to be in families who will not escape the cap, the 95%, or that part of the 95% who remain subject to the cap. That's the fundamental problem. We say all of that in our printed case at MS 8351. And fundamentally, we summarise it in paragraph 170. And it's points Roman 1 to Roman 5. It's actually MS 8352, which contains the meat of paragraph 170, as it were. Or can read those, they make the point, I think, that I've just made. So for those reasons, we say that the finding of 3 members of the court in SG that there was a breach of Article 3 applies to the revised cap. We will further say, when we come to, by reference in particular to Lord Wilson's judgment in Matheson, that Article 3 is relevant to the consideration of this. I'll come to that in a due course, not very long due course. But the next thing on my agenda was to deal with the correct characterisation of the discriminatory effect of the cap. And I'm anxious to do that initially without reference to a label of direct or indirect. I just want to see what are the characteristics of the cap that need to be dealt with when one gets to the justification argument.
Can I just raise, if you're leaving what we said in SG,
Yes.
I mean, it's said against, I think probably technically rightly, that it's not in any sense sort of binding. I mean, there were 3 opinions.
Oh, yes.
We've obviously got to say how it's relevant at all in a domestic law setting, but that comes to matters
Yes.
and so on. But as to its effects, it's just simply 3 opinions of 3 members of this court.
I accept that. I mean, I think there are times when we've talked about there being 2 different majorities,
Yes.
but I've seen what the Secretary of State says about what the ratio is, and I accept that analysis. The ratio is the bit of the thinking that disposes of the case, if I can put it like that.
Yeah, thank you.
So I completely agree that the 7 of you are not bound by the approach.
We wouldn't be anyway.
Well, exactly.
That's why there are
I've got
7
that
of us.
far too. I mean, in a sense, I mean,
At the invitation of the Secretary of State. So.
yeah, I have to say, I mean, in relation to SG in particular, there's an artificiality about talking about binding ratios or non-binding ratios, because this court can depart from its own previous decisions anyway. It's not an easy case to read or apply, and frankly, one would expect the court, this court, present court, to make up its own mind about what the right answer was, and I really don't demur from that at all.
Actually, I was wrong to say we're not bound. We are bound unless.
Yes.
Well, we're bound by
You're
the
bound by
ratio.
the ratio unless you decide to depart from
Yes.
it.
In other words, we're not bound.
Which leaves the knock-on question, what is the ratio? But I'm not going to go there.
Whatever it is, our views on Art 3.1 were not part of the ratio.
Exactly. Well, Mr. Leventhal says the mechanics of the relevance of Article 3, as opposed to the answer whether there's a breach in this particular instance, is applied in Matheson, and that is binding unless the court departs from it. So, now, trying to work out what's happening in relation to the cap, there are it's possible to discern 2 aspects of the discriminatory effect. First is the statistical impact. We've just been looking at that, and we've set it out in paragraphs 50 to 54 of our case at MS 8311 to 8313. So we say, a straightforward discrimination analysis, there is a disproportionate impact on lone parents or the children of lone parents, and one gets to the justification stage, whatever label you apply to the discrimination. That is what happened in SG.
And what is it that you say has to be justified?
Well, coming to that.
Okay.
That's one of the intellectual teasers of my evening.
Yes, well, we touched on it yesterday.
We did indeed. You can't say I wasn't warned. I'll come to that. And secondly, that purely statistical evidence, which is our paragraphs 50 to 54, is buttressed by the fact that the statutory structure of the cap in itself creates greater difficulties for lone parents than for people who are not lone parents, putting that as neutrally as I can. And that's the point that we make in our printed case at paragraph 70, MS 8319. Sorry. Myself now. The basic submission before behind paragraph 70 we've made already, but that the way in which the cap operates in relation to what is expected of a lone parent as a result of the statutory scheme is that a lone parent has by herself to do nearly as much, I'm not trying to quantify it, as the two members of a couple will have to in terms of the combined work and childcare to escape the cap. Now, we've called that direct discrimination, but whatever the label, it's part of the effect that has to be taken on board when we come to the justification argument. My first submission, therefore, is that that correct characterisation of the overall effect is important, and for reasons I'll just come to, matters more than whether one applies a label of direct or indirect discrimination. I'm going to try to illustrate that by reference to what Baroness Hale said in paragraphs 188 and 189 of SG. As a way on the as a stepping stone on the route to that, can I just ask the court to pick up the bedroom tax spare room subsidy case MA in the Court of Appeal, which is in bundle 8, tab 68, page 46, and I haven't written down the MS number. The report starts at MS 2800.
Sorry, what's the MS number you wanted?
Well, the report starts at 2800. The passage is at 2814 and following. The whole passage is paragraphs 39 to 47 in a judgment of Lord Dyson. This, of course, is the bedroom tax case, which included Carmichael, where the Court of Appeal held there was justification was justified and this court disagreed. Sorry, how the discrimination was justified and this court disagreed. And together with another group of disabled people who didn't have quite the same sharp focus as Carmichael. And the court will see that consideration starting in paragraph 39. And then, for present purposes, we can pick it up at paragraph 43. There's been much discussion in this case on whether this discrimination, which is identified in the earlier paragraphs, is direct or indirect discrimination, or whether it's a species of discrimination of the kind which was recognised by the European Court of Human Rights in Slimnos. And then the quote is set out. 44, the Divisional Court decided discrimination in the present case was most appropriately classified as Slimnos discrimination. For the purposes of deciding discrimination questions arising under our domestic law, it is necessary to determine whether discrimination is direct or indirect, not least because the latter can be justified and the former cannot. But the European Court of Human Rights has adopted a less complicated approach, see Baroness Hale and A.L. Serbia, and Lord Nichols in Carson. And the quotation from Lord Nichols in Carson is set out at the top of page 2816. Then there's a citation from Steck, and then the meat of it is 46. In contrast to domestic and European Union equality law, the Strasbourg case law does not speak of direct or indirect discrimination. When analysing the extent of justification required, it's the substance of the discrimination which matters, not its form. I doubt whether it matters whether discrimination is properly to be characterised as direct, indirect, or synonymous. It is said that it does matter because the bar is set higher for the justification of direct than for indirect or synonymous discrimination. But it's clear from what Baroness Hale said in Humphreys that in a benefits case, the test for justification is the same, however the discrimination is characterised. I shall return to justification later. And then he does say, 47, in this case, in case the classification question is material, I shall content myself with saying that I agree with Lord Justice Laws, that for reasons he gives in the report, the discrimination in this case is one of indirect or synonymous discrimination, not necessary to distinguish between the two. As a matter of substance, Regulation B13 discriminates against disabled persons on the ground of disability for the reasons that I have given. Now, pausing there, we have a situation in which there is an obvious disparate impact, see the statistics, where the particular problems for lone parents getting off the cap are built to an extent into the structure of the scheme. See our submissions on the shape of the statute. And it's that substance of the discrimination which needs to be justified, we respectfully submit. And it doesn't, at the end of the day, matter, for reasons I'll come to as the next stage, whether you call it direct or indirect discrimination. So the mental exercise is pretty well exactly the same. And if I can go from there to what the Lady Baroness Hale said in SG, which, subject to a gloss to be found in a very useful footnote of Miss Mountfield's, we say is the correct approach. I've got her permission to refer to it. So, can we go back to SG?
Can I be sure that I'm following, that I've got the structure of the argument?
Yes.
In a nutshell, are you saying that the statistics demonstrate that the cap affects more families with single parents than families with two parents?
Yes.
And so that's a differential impact. And you say that that can't be justified because the legitimate aim being pursued to incentivize people to work is one which that cohort are less able to comply with. That's it in a nutshell.
The simple part of our case is that it does have a disparate impact. See the statistics. That's unsurprising given the practical realities which Baroness Hale refers to in SG, and also the additional element we're bringing to the feast, as it were, this time round. It reflects the statutory structure. And you then ask, can you justify it? Well, the cohort that's being particularly disadvantaged is the one that is least appropriate to apply the work incentivisation scheme to. And that's very close to what 3 members of the court said in SG. But, yeah. And that is the structure, yeah. And so if we go back to SG, it's it's at MS 335 starts, and the relevant paragraphs are 188 and 189.
Page?
Sorry.
Sorry about that.
390.
It's a very long case, so starting at the
Yeah,
beginning would take a long time to find it.
It's 390. And your leadership set out STEC in the first part of 188, then says underneath that 2 points are clear from this. The first is not the scheme as a whole which has to be justified, but its discriminatory effect, CA and AL. Not enough for the government to explain why they brought in a benefit cap scheme. That can be readily understood. They have to explain why they brought in the scheme in a way which which has disproportionately adverse effects on women. So that's the first step. On the face of it, it's pausing there. What needs to be justified is the discriminatory effect. But then your leadership went on to say in 189, however, it's important to understand that what is needed to justify indirect discrimination is different from what is needed to justify direct discrimination. Indirect discrimination is necessary to justify treating women differently from men. In indirect discrimination, by definition, women and men are treated in the same way. The measure in question is neutral on its face, not necessarily targeted at women or intended to treat them less favourably from men. But women are disproportionately affected either because there are many more of them affected by men, or because they will find it harder to comply with it. It's therefore the measure itself which has to be justified, rather than the fact that women are disproportionately affected by it. Then your leadership gives the classic example of an age bar. It says just below letter C, the question therefore is whether the age bar can be independently justified, and then refers to section 19 of the 2010 Equality Act and Hugendijk. Now, there is a potential tension between 188 and 189, but the squaring of the circle is footnote 13, which I'm very grateful for.
I expect I shall be too.
Yeah, if the court has the interveners bundle,
My lady, before Mr. Drabble gets to footnote 13, there's a typo mistake in footnote 13.
Well, let's get to it. Let's find it first, and then you can tell us what the typing mistake is.
I think I know the typo, so
Yes.
at least I think I'm being told the typo. Yes. Well, yes.
Let's find it first.
Yeah.
Which page are we on?
What's the MS?
Right, MS 10475.
Gosh. Yes, we've got. We are very grateful for the fact that we seem to have everything in one file virtually, apart from these new stuff.
Apart from me.
But you're working on it, Mr. Drabble.
The Lordship told me to, but whether I shall accept the advice is a different matter.
You'd be well advised to accept it.
I got the picture. But so the footnote is a footnote to paragraph 25. So paragraph 25 says the discriminatory effect of the revised benefit cap is characterised by parties as indirect discrimination, what was justified as the introduction of a scheme in a way which has disproportionately adverse effects on the status group. And that's a reference to paragraph 188. The resulting detriment on this group of being disproportionately affected in this way is at the heart of what has to be justified. And then the footnote goes on to refer to the tension with 189 and says, when Lady Hale continued, it's the measure itself which has to be justified rather than the fact that women are disproportionately affected by it. She was plainly not suggesting that the harsh impact of the measure is to be left out of account. Same is true under indirect discrimination. See Secretary of State against Elias, and the typo is that paragraph 164 should be paragraph 151. Referring to the need to weigh the need for the measure against the seriousness of the detriment to the affected group. So the balancing exercise, a fair balance, is to look at the policy objectives being pursued by the CAP in this case, which include the 3 aims, and on this approach weigh them against the detriment to lone parents or the children of lone parents. Now that's obviously articulated as applying in the case of indirect discrimination, but then I go back to Lord Dyson in MA, so it doesn't really matter. You isolate precisely what are the discriminatory effects you're talking about, the statistics and the structure of the scheme. You look at whether the need for the measure outweighs the seriousness of the detriment to the disadvantaged group. I feel we'll have our own chance to say what I'm getting wrong about that submission, but that is the submission. Now, put like that, I'm not sure that in this case it really matters whether you call it direct or indirect discrimination. It's a truth that some of the effects are part of the statutory structure. So I've done my best to answer Lord Hugh's question about the approach to justification. That's the answer we give. Those are my submissions on the nature of the discrimination in play. That leaves just some short aspects of, I say short, or rather large questions. What the current position is on status. Is it legitimate for us to be identifying lone parents as having a status within the fallout words of Article 14, or the children of lone parents as having such a status? Then some submissions short submissions on the ambit of Article 8. And then
Well, you're a quarter of an hour, as I.
in a quarter of an hour.
Yes.
I'm fully aware of that. And
We'll try and be quiet.
I shall do it, I think. Well, famous last words, but I think I shall do it.
I just shall do it.
And the final one is the relevance of Article 3 to this exercise, just in terms of case law. So status, we have dealt with this in our printed case at 96 to 102. Which is at MS 8328. And essentially that passage refers to, first of all, RJM. I'm not going to take the court to the passage. The court will be familiar with it, but the passage in Lord Neuberger's judgment, the whole of the passage is actually highly illuminating on all of this. But then we move on to Matheson, which the court will find in bundle 2 of the authorities bundles. MS 223. Yes, and the relevant passage really starts at 232, MS 232, paragraph 19, under the heading Status. And court will see that in paragraph 21, Lord Wilson refers to AL Serbia, and then to RJM, ending just above letter F, with Lord Walker in RJM referring to a wider circle which included acquired characteristics and so on. And in reference to Clift, and then the conclusion is reached in paragraphs 22 and 23, and in particular 23, that Cameron, who was the child in hospital in the case, did, by virtue of being a child in hospital, have a sufficient status for the Article 14 exercise. And I mean, our short submission is that if that is right, the child of a lone parent has a rather more obvious status for reasons which we've given in the printed case. And then finally, court should see relatively recent case of Stevenson, which is at 1082, volume 10, tab 82, MS 3344. And if your lordships and my lady look at 3354, there's a passage which runs from paragraphs 36 to 41, which comes to the conclusion in paragraph 41, the end of the paragraph, that the remarks in Khayyam provide a realistic recognition of the direction in which the Strasbourg Court's jurisprudence is moving and to reinforce Lord Wilson's conclusion that if the alleged discrimination falls within the scope of a convention right, the question of status will normally be answered in the claimant's favour on the basis that he or she possesses either a personal characteristic or an identifiable characteristic assessed in the light of all the circumstances of the case. In the majority of cases, it's probably now safe to say that the need to establish status as a separate requirement has diminished almost to a vanishing point. And then we get the application of that, which was applied in a case about the timing of a claim for benefit, whether there was a different status gained by people who claimed the benefit before the 5th of January 2009 as opposed to those who claimed it after the 5th of January 2009, with an affirmative answer. There was a difference in status in the passage at 47 to 51. I won't take any more time on that. The court can see the passage. Conclusion being expressed at the end of paragraph 50. So those are our submissions on status. On ambit, that is the ambit of Article 8, we've dealt with this in our printed case, paragraphs 103 to 114, MS 8330. And if court looks over the page at 8331, we refer to Petrovich, which I'm not going to take the court to now, although it's, in my respectful submission, a very important case on ambit, certainly in social security terms. The case that is very, very close, and indeed we would say conclusive, if this court follows the Strasbourg court, is the one we refer to in paragraph 108, Ockpitz, which this court will find at volume 12 of the authorities bundle. Tab 101, MS 4048, and it's a case about what are described as child benefits. And there's no obvious reason on the face of the report why we aren't dealing with a benefit that's the direct equivalent of our child benefit or of our child tax credit. It's slightly dangerous carrying out comparative exercises of that sort, but no particular feature of the benefit seems to sound in the conclusion, which is in paragraphs 26 to 32, MS 4053, and in particular paragraph 32, where the court itself says, by granting child benefits, states are able to demonstrate their respect for family life within the meaning of Article 8 of the Convention. The benefits therefore come within the scope of that provision. It follows that Article 14, taken together with Article 8, is applicable in the present case. On the face of it, that reasoning is directly transferable to the present case. We have given the court, go back to our printed case,
Was there any argument about it?
I don't think there was. I mean, it seems to be almost to take it, I don't know whether that helps or hinders, but what there certainly isn't is any discussion of the particular features of Austrian or of the child benefit in question.
It certainly demonstrates support for family. Plainly, that's the whole point of it.
Yes.
Does it follow from that that one achieves a right to it?
No, that's the ambit engagement dichotomy.
Meaning?
Meaning that it's sufficient for an Article 14 case that you are within the ambit of the right.
Right.
There's no right to child benefit, but if the state provides child benefit, it must do so on a non-discriminatory basis.
Yes, that I understand.
Yeah,
But
well, that's the point being made.
I'm on Article 8 at the moment.
Well, there is no right, I fully accept, within the terms of Article 8.1 to child benefit. In other words, a failure to pay child benefit will not itself engage or breach Article 8.1. But if you do something which is a mode of showing respect for family life, to use the wording of 8.1, then you're within the ambit of Article 8 for Article 14 purposes. That's the analysis.
It seems to be treated as an application of Petrovich.
Yes. I haven't gone to Petrovich, but Petrovich is very important.
I'm looking at it at the moment, and there it was a matter of argument, and the argument against was that you should distinguish between welfare policy and matters relating to Article 8, and that was obviously rejected.
Yes. I mean, I say against myself, Petrovich is relatively early in this history of discussion of ambit. It is about a parental leave allowance. The father lost because of the state of the European consensus at the time. But the general idea that the provision of a benefit of a purpose which props up the family, if I can use that language, is a mode of showing support for the family, and therefore within the ambit is shown by Petrovich, shown by Opitz, and has been followed by the other decisions of the domestic courts.
Well, you've 2 minutes to deal with Article 3.
Yeah. I've given there are other references to Article 8. Now let's go on to Article 3.
Well, perhaps Mr. Wise is going to say something about it.
Yeah, well, can I just do one thing? We have, in our printed case, dealt with Article 8, paragraphs 116 to 122, at MS 8334. Bearing in mind I've got 2 minutes, can I just say that your ladyship, Baroness Hale, referred in SG at, I think, paragraph 211 or shortly thereafter, MS 397, to a case called GLOR, G-L-O-R, which the court will find in the present papers at bundle 16, tab 145, MS 9350. With 1 minute to go, take your court there. But we do say, probably unsurprisingly, that when one goes to GLOR, we do find international material, including various decisions and reports, in other words, not binding treaties, being used to illuminate a justification case under Article 14. basic Strasbourg approach seems to be to say that we will look at the overall international background, including reports and decisions, and therefore we would say axiomatically the general comment under the UNCRC to illuminate a justification case. And then I will leave Mr. Wise to deal with Matheson, if he wishes to. He knows it very well, knows it better than I do. But the reference is to Bundle 2 of the Authorities Bundle, tab 13, and it's MS 240, paragraphs 41 to 44.
The MS reference?
It's MS, case starts at MS 223, the passage is at MS 240, the paragraphs are 41 to 44. Getting that right. I'm taking that rather fast, but it's a very important part of the case, actually, from our point of view. Because
It is indeed a very important part of the case.
Yes.
But you are out of time, Mr. Drummond.
Exactly. Those are my submissions, therefore. Unless there's anything else on which I can help at this moment in time, those are my submissions.
Thank you very much, Mr. Drummond. Ms. Leventhal? Mr. Wise.
My lady, my lords, one moment. You'll see that this case comes to this court specifically on appeal from the decision of the Court of Appeal. In this matter, the Court of Appeal reversing the order of the High Court to the effect that the 2016 housing benefit regulations unlawfully discriminate against, firstly, lone parents of children under 2 and children under 2 who have lone parents. The appeal in form raises 4 issues which are dealt with in the statement of facts and issues which the court has. I intend to focus my submissions on those 4 points. They're firstly, to put it shortly, with respect to discrimination. And when dealing with discrimination, I need to deal with the Thlimenos type discrimination that is alleged in this case, and in particular whether the appellants are in a sufficiently different position to others such that prima facie discrimination, there is prima facie discrimination which requires justification. That's the first issue, discrimination. Secondly, we propose to deal with justification itself, looking at some of the statistical evidence and particularly focusing on the role of Parliament and the role of the courts in this case, bearing in mind the concerns of some members of the court in the SG case. Thirdly, we consider the position of the United Nations Convention on the Rights of the Child, which of course is relevant to justification with respect to the children, the child appellants. And fourthly, we propose to deal with the common law. The court will see, in addition to those issues that we raise, there are 6 cross-appeal points raised by the Secretary of State. We've dealt with those in writing, and the court should have that document in the supplementary bundle 2 of 2 at tab 8, MS 10339.
MS?
10339, my lord.
Thank you.
There isn't time in the time that we have to go through all of those 6 issues, but if there are particular concerns the court has with respect to them, then we'll deal with them as best we can. But turning to the 4 primary issues that arise in this appeal then, looking firstly at the prima facie discrimination and failure to treat differently issue, we firstly have to consider what the relevant question for the court is. Now, it's said repeatedly that we're contending for a Thlimenos type discrimination. Can I, at the outset, take the court to that case? It's in the Authorities Bundle, Volume 12, MS 4179. court will no doubt be aware of the background which you get from the head note on page 4179, but particularly want to take the court to paragraphs 44 through to 46. 44 is the often quoted paragraph, and you'll see from the end of the preceding paragraph that here it was the right of freedom of thought, conscience and religion guaranteed by Article 9 that was in play or linked to use that language to the Article 8 rights. And so at 44, we see, if we can pick it up halfway through the paragraph, we see, however, the court considered that this is not the only facet of the prohibition of discrimination in Article 14. The right not to be discriminated against in the enjoyment of the rights guaranteed under the Convention is also violated when states, without an objective and reasonable justification, fail to treat different persons whose situations are significantly different. And it then goes on, if you can read through to paragraph 46. The next question to be addressed is whether Article 14 has been complied with. Accordingly to its case law, the court will have to examine whether the failure to treat the applicant differently from other persons convicted of a felony pursued a legitimate aim. If it did, the court will have to examine whether there was a reasonable relationship of proportionality between the means employed and the aim sought to be realised. And that's important because that sets out the parameters of what this type of discrimination is concerned with. It's the failure to treat the applicant differently from other persons, the other persons caught by the measure or the rule. So we don't have an exact comparator situation in these sorts of cases, as we're familiar with in domestic law. And the circumstances of Mr. Thlemenos himself demonstrates very well the way in which this type of discrimination has to be conceptualised. And so, bearing that in mind, we come to consider the language that is used in the case. You'll see, if we keep that page open at 4192 open, you'll see the language used there is situations that are significantly different from the generality, as we've said. But significantly there doesn't anticipate or require any particular threshold, whether numerical or otherwise, and neither does it require the circumstances to be unique or even exceptional. They just have to be significantly different. All that significantly means in this context, we'd suggest, is not insignificant, particularly when, with respect to its relevance to the rule or the measures that are being applied to them. Furthermore, when one looks at the way in which the court dealt with the case there, it's clear that establishing the situation of the situation of the particular group is significantly different doesn't involve any technical or still less any statistical analysis. There's no need for that in a case such as this. Any such detailed analysis is a question for justification and proportionality. All we have to do is establish that basic situation of being significantly different. And so the debate about whether we're in the territory of direct or indirect discrimination simply isn't an issue in this case. That point doesn't arise. This isn't a case like SG, which was a quintessential case of indirect discrimination, where what felt to be justified was the general rule that produced the indirect discrimination. This is a different species. Thlemenos discrimination, what needs to be justified here is not the general rule, but it is why a different case has not been treated differently from the generality, why this case hasn't been treated differently from the generality, and particularly here, why no exception has been made for those who are adversely affected. And when put like that, it's quite a straightforward, we would say, concept. Now, our case is, of course, that under this heading or species of discrimination, that an exception should have been made for my clients. We've seen from Mr. Drabble's trawl through the statutory regime in this case that this regime itself permits for exceptions to the benefit cap to be made. We get that from section 96(4)(c) of the Welfare Reform Act 2012. And then we see in the regulations, I think Mr. Drabble took the court to yesterday, specifically regulation 75E, but we also have 75F, which sets out a number of exceptions to the general rule. And so the scheme already exempts various groups, and included within those groups, when one looks through the list set out in regulation 75E, are particular groups of people for whom there are significant barriers to work due to their caring responsibilities. For example, those in receipt of carers allowance and those who are kinship carers. And so the discrimination here, the disadvantage here, can be viewed from two directions. And firstly, is there an objective and reasonable justification for failing to treat our particular cohort differently to the generality of those affected by the cap? But secondly, one can also characterise it in this way: having chosen to exempt those in receipt of carers allowance or kinship allowance from the cap due to their caring responsibilities, why has the respondent failed to make an exemption to reflect the analogous position of our cohort of lone parents and very young dependent children? And that, in essence, is what we say on that. Now, the majority of the Court of Appeal, we say, erred in two important respects. Can we turn the Court of Appeal's judgment up? It's in the core volume, of course. MS 4552. It's the judgment of Sir Patrick Elias, of course. And we're looking here at paragraph 115. Can I just invite the court to read that short paragraph in the light of what we've just said?
That is presumably than.
Apologise, lady.
That is than in the third line. Mr. Sheldon agrees.
Oh, yes.
Not picked up in our
No,
corrections.
we missed that. Yes.
So 115 is...
So the first flaw we say that Sir Patrick made there was to draw a comparison between our cohorts with lone parents with older children. And we say that's a fundamental flaw. For this species of discrimination, the comparator, if one talks in terms of comparators, is the generality of those affected by the measure, not any specific group of people who are affected by the measure. And secondly, we see that...
Sorry, the right comparison is with everybody else?
Yes.
Thank you.
And we get that from Flumenos itself.
Right.
Well, I'm not sure I understand that. I mean, Flumenos itself, on the facts, that was the position. It wasn't suggested that anyone else was had a particular problem. But here what he's saying is that people with older children would have similar problems. And therefore there's no particular reason to, as I understand it, to pick out children under 2 as being a particular...
Yes, but the disadvantage, my lord, is in relation to the group as a whole. It's quite easy to slice different groups and compare our cohort with one or another group that is
one another.
affected.
I mean, what I don't
The whole.
understand, and it's maybe my fault, is why you can't say of each group within the generality that it may have particular problems, and therefore that's entitled to be treated as a separate cohort for your purposes.
Well, it may be that that analysis becomes relevant at the justification stage, my lord, but not when one's considering when there's a difference in treatment in the first place. Because the question arises, who are we being treated differently than? The point that my Lord Hughes made to Mr. Drabble yesterday. The second error that we say that Sir Patrick made is in the final sentence, where he's concerned with the facing substantially greater difficulties than lone parents with older children. So if you'll just bear with me one moment. It's the virtually impossible test that Sir Patrick raises in that paragraph. And we see that, sorry, it's fourth line down. In obtaining work, nor indeed is it virtually impossible for them to go to work because of their childcare responsibilities. Now, that is, so far as disadvantage is concerned, setting the threshold far too high. There's no warrant for having to establish that it's virtually impossible
I think
for my clients.
Is he not simply responding to the way it had been put by Mr. Justice Collins at first instance? I think he had used that expression.
Yeah.
Is that correct? I'm sorry, Lord,
so.
I picked that, perhaps mischaracterised that. But nevertheless, it's that's a flawed approach. Mr. Justice Collins, you're correct, my Lord, of course, he did say that, but that wasn't in the context of whether there was the disadvantage or Flemenus type discrimination. And Sir Patrick then incorporates that within this analysis, and we say that he was wrong to do so. So the standard is only of significant difference, not of virtual impossibility. One doesn't have to go that far. So we say that the approach of the Court of Appeal was fundamentally flawed, but that, of course, only takes us so far. The necessary question that arises is whether on a correct analysis, my clients satisfy this test, i.e., are they indeed sufficiently different? And we say they are. We say they are for a whole host of reasons. But most of those were picked up by Lord Justice McComb in his dissenting judgment in the Court of Appeal. And if we can just turn to that, it's paragraph 156, which is MS 4566. And you'll see there that in the first sentence, Lord Justice McComb says this: thus the judge found that this group had significant differences in circumstances from others affected. The grounds upon which the claimants sought to establish their distinct circumstances were summarised from the extensive evidential materials before the court below in the skeleton argument of the claimants' counsel before the judge, and then sets out what they are. And the court has all those features there. If I can invite you to quickly glance over A, B, C and D that he sets out. And then he refers to a number of other features of the case. And at 161, MS 4568, says, I regret that I am unable to agree with Sir Patrick that the judge erred in finding irrelevant Flemenus discrimination, in this case. We don't need to trouble with the next part of the paragraph at this stage. So, it's set out there in some detail why we say there's a significant difference for our group. We emphasise at this stage, firstly, the factors that make it particularly difficult for lone parents of children under 2 to escape the cap by entering into work, especially the unavailability of any free childcare from the state, a point that's been touched on by my learned friend Mr. Drabble earlier. And secondly, we emphasise the uncontested evidence in this case that under 2s are particularly badly affected by the deprivations caused by the cap. I shall take the court to the specific evidence in due course. So we're referring there to the parents and the children, because of course we have to establish in our case the menos discrimination in respect of both cohorts, parents of children under 2 and the children affected. So looking at those 2 broad areas, firstly the particular difficulty that the parents have, these particular parents have to escape the cap by entering work, we can see that there's a number of factors that are touched on by Lord Justice McComb. But before we look at those in any more detail, I invite the court at the outset to have regard to the intuitive point that children under the age of 2 are babies and toddlers. And with respect to them, their parents, and the lone parents in particular, have caring responsibilities which are considerably more onerous than others affected by the cap.
Well, it's a sliding scale, isn't it? That's the problem.
It is.
Fastened on 2.
Yes.
No doubt for reasons which appear to be good.
Yes.
But what you're setting out to do is to say, as I understand it, in order to bring yourself within the Thlimenos principle, that you can identify in that cohort something which doesn't exist elsewhere.
Yes, yes. And that's a bright line that's been drawn by the state on a number of occasions, as we've seen during the course of this hearing already. For example, childcare, and for example, conditionality on receipt of income support or universal credit. So the state draws that distinction anyway.
One of the lines in relation to income support, isn't it? In relation to conditionality, there are lines at, is it 1, 2, 3?
There are, of course, yes.
4 and 5.
Yes, but they draw a line there.
Yes.
They do.
That's enough for your purposes, you say?
Well, that combined with other factors.
Okay. Right. So it's childcare and conditionality.
But of course, one doesn't have to. Just to pick your Lordship's point up again and perhaps explore that a little bit more. We don't have to establish that we are the only group that are significantly different. So in the Thlimenos case, there may well have been others in Cyprus who had committed crimes that were that would be considered in the same way that Mr. Thlimenos was considered, i.e., it was inappropriate as a result of whatever they'd done to disbar them from being a member of the Chartered Institute of Accountants or whatever the equivalent was in Cyprus at the time. It doesn't have to be an exclusive group. And that's the point that, that touches on the point that Lord Justice McComb also made in his dissenting judgment. Just because the smaller group are discriminated against doesn't mean that a larger group may not be discriminated or a different group. So, for example, in Thlimenos, of course, we've got the Jehovah's Witness. There may well have been a Quaker in Cyprus in exactly the same, or in a very similar situation. Or there may be a very different set of circumstances where it's a minor misdemeanor where it would be inappropriate and place them in a significantly different place. Yeah. So one can analyse it in terms of bright lines, but we don't have to in this case. So we were starting with what we described as the intuitive point about the difficulties, the particular difficulties faced by babies and toddlers and those with caring responsibilities for them. But of course, children under 2 includes breastfed babies that are in the early stages of walking or talking. And so in those circumstances, we'd suggest it's hardly surprising if lone parents with children under 2 and the children themselves were not in a significantly different position than lone parents of older children and older children themselves. So that's a broad point that underpins all the other points we say. And that's touched on again by Lord Justice McComb, if we've still got his judgment out. It's paragraph 171 at MS 4572. Can I just invite, it's only, I think, 6 lines, that paragraph. Can I just invite members of the court to read that? And so that's the common sense point that the judge raises there, and we would echo that, and that being an appropriate approach. Now, we've heard something about the specific obstacles faced by lone parents entering into and maintaining work, and how that's reflected in the state's conditionality approach to the benefits systems as a whole. But lone parents with children under 2 are unique as a class in that they are not required to work or look for work as a condition of receipt of key welfare benefits. All they're required to do is go to 1 or 2 work-focused interviews in the first 2 years of the child's life. And they're unique, so the state is carving that group out as being different for very good reason. Bearing in mind, we're only trying to establish here that we're significantly different. And what we're not saying here is just because lone parents of children are under 2 are not required to work as a condition of receipt of benefits, it logically follows that their benefits should not be capped. That's not the submission we're making at the moment. What we're saying is the conditionality in the benefit system, whereby lone parents of children under 2 are specifically not required to work, is a recognition that they face special difficulties in working, and demonstrates that they meet the significantly different threshold for Flimenos-type discrimination. My learned friend Mr. Drabble touched upon childcare, and he handed the court up a note with respect to that. Similar considerations apply here as well. There is free childcare provided by the state for two-year-old children who fall within specific categories. It's targeted at children in disadvantaged families by reference to the state benefits that those families receive. And we see that, we don't need to go to it now, but for members of the court's note, that derives from Section 7 of the Childcare Act 2006, which is MS 8508, read together with the local authority duty to secure early years provision free of charge regulations, 2014, which we've got in the authorities. In fact, can we go to that? It's Authorities Bundle 14, tab 123. At MS 8515.
Could you give me the MS number again?
8515, my lord.
8515.
can we start by looking at Regulation 1? And we see that these regulations refer to the 2006 Act, meaning the Childcare Act that we've just referred to. As I say, we've got that in the papers if you want to look at it. But eligible child is defined over the page at 8516. It's A, so this is Regulation 1 to A. And you'll see there in Roman numerals 1 to 8 the list of benefits to which a parent has to be entitled for the child to be an eligible child. So that's a specific provision set out there for...
Once you have that, what comes with it?
Yes, I'm just looking at that. If you go over the page, 8519, got prescribed description of a young child, and more pertinently to your Lordship's question, if we go over to the next page, 8520, availability of early years provision. Did you see Regulation 4.1, my Lord?
Yeah.
The reference there to 570 hours. That's 15 hours a week for 38 weeks a year. Does your Lordship have that?
That's childcare, effectively.
Yes.
And that's for any child whose parents are getting back to
Those benefits.
child tax credit, but not working tax credit. So is that a non-working parent, typically?
It will typically be. I'm not sure what working tax credit run on is, my Lord, but I think it's probably where they've been in receipt of... Perhaps my learning friend can help on that.
My Lord, working tax credit is under B.
Is it?
No. I was looking at A1, child tax credit, but not also working tax credit. What I was asking was whether that was typically a non-working household.
It will typically be. I'm not sure if it's exclusively, but we can find out, my Lord.
And that's of any age, is it? A child?
And the prescribed, if you can go over the page again, my Lord, 8519. We've got the ages of the children, at Regulation 3.
Yes.
Has attained the age of 2 years. Does your Lordship have that 3.2a?
Has attained the age of 2. Right.
So there's a duty to secure this for each child who qualifies, basically.
Yes, aged over 2.
Yes.
Yeah.
No,
And that's the point. I'm sure for very good reason the state's decided that that children in these circumstances should be given this additional support at that age. But the important thing is it starts at age 2. Now what then, in terms of childcare, preschool, nursery education, childcare, however one wants to characterise it, the state then provides 15 hours of free childcare for all 3 and 4-year-olds. And then that increases to 30 hours for 3 and 4-year-olds for children of working parents. Again, we don't fall within those groups. The relevant statutory provisions with respect to that childcare, again, Section 7 of the Childcare Act 2006, which is the regulation-making provision, and the relevant regulations, also in the same volume, I don't have the MS number. It's within the... We can get back to you with the MS number. I'm sorry, I don't have
tab
that
number?
in my notes. It's,
Do you have a tab number?
yes, it's 123, my Lord.
123.
I just need to check that. I can do that over the lunch adjournment. I might be conflating the two sets of regulations, but I don't think it's a controversial point that there's the 15 hours of free childcare for all 3 and 4-year-old children. And then, of course...
123 is 8515.
Yeah. Can I come back to you after the break, my lord, on that? I think I've got the wrong reference in my note with respect to that. But I don't think it's controversial in any event, but we'll get the proper reference for you. So we've got the 2-year-old, we've got the provision for the disadvantaged 2-year-olds, we've got the provision for all 3- and 4-year-olds at 15 hours, and we've got the provision for 3- and 4-year-olds of working households of 30 hours, and then of course we get the compulsory school provision from the age of 5 from the 1996 Education Act. So the important point is that none of this applies to children under the age of 2. And this comes back to my Lord Hughes's point about why is the line drawn here? Why are we drawing? What's significantly different about this cohort of people than the generality? And of course, what's specific about the children also applies to the parents of those children as well. One has to look at them together. Now, what the government say about that, if we look at the impact assessment, the pertinent impact assessment here, MS 5490, if I can, that's in our appendix 3. The appendix, the paper number 979, for those of you who are working not online. So I must start at the beginning of this document. This document starts at 5478.
I haven't got that numbering. Give me another, please.
Sorry, 967, my
Thank
lord,
you.
in Appendix 3. Does your lordship have that?
I do.
Sorry, if we can go back a page. The front page of it is at 966, 9477 of the MS. We've got the date on here just to identify when it was produced. You'll see this is an August 2016 impact assessment on the Welfare Reform Act. Well, Mr. Drabble took you to the first couple of boxes on page on the first page. But can we go over to page, for present purposes, to page 5490, MS 5490, paper number 979. And we see the heading there, childcare costs. This is a subheading, of course, from what we get towards the bottom of the previous page. What are we doing in mitigation? And there's 2 paragraphs there that are set out dealing with childcare costs as mitigation for any adverse impact that the benefit cap may have on children and the families of children. And what's striking about that is that the mitigation referred to, the childcare costs that are referred to there, are all with respect to 3- and 4-year-olds and the most disadvantaged 2-year-olds, which we looked at a few moments ago. So there's no recognition there of the specific difficulties that children under the age of 2 and their parents are faced with. Now, the respondent makes the point that the state will pay a proportion of childcare costs in certain circumstances. Up to 70% of childcare costs paid through working tax credit and up to 85% where a person is on universal credit. But of course, a person's got to be in work in order to access those provisions. So that doesn't help people getting out of work in the first place. And so that isn't a reason why, it certainly isn't a reason why we are not significantly different than others. So that then deals with childcare and the benefits system. We turn to look then at the statistical evidence as well, and the court may have seen in this case that we produced, throughout the course of these proceedings, 3 expert reports from an economist called James Harvey, and I'll take the court to those reports in a few moments. I invite the court to read those reports with very great care, because it was important to unpick the statistics that were being used by the Secretary of State, once we showed that they weren't as clear as they might be, to put the most favourable gloss on them. Now, although, as we've said earlier, it's not necessary to prove that this cohort is significantly different by reference to statistical evidence, it is helpful to look at what the evidence shows about this cohort. And it's clearly the case that in the light of this evidence, and in a case such as this, the more stark the differences, the harder it will be to justify not treating this group differently. And so, if we look at firstly, the respondents' own statistical evidence, that shows that lone parents of children under 2 make up a very substantial proportion of capped households. I'm not sure if we've seen this yet, but we get this from the Ward statement that we had recently. If we can just turn that up, it's MS 9825. That's the additional evidence, volume 1.
Mr. Wise, can I just be sure I've understood this? If you're a single mother, for example, of a child under 2, you do qualify for childcare support if you're in work. But is that right?
Free childcare support at ages 3 and 4, when the child is 3 and 4, my lord. Yes.
I think my lord was asking, can I understand this?
Yeah.
That if you are actually in work and have a child or children under 2, you will get a proportion of that.
Yes.
Supported.
Yes.
Right. Either 75 or 85.
Yes.
So
Yes.
Your point is that you have to be in work in order to do
Absolutely.
it.
Yes.
The contrary point, presumably, is that you can safely get a job knowing that you will get the...
well, that begs the question, safely getting
that
a
was
job.
going to be my next question.
Yes.
I was going to say, if you don't have any childcare support when you don't have a job, and you then find somebody to look after your 18-month-old toddler,
Yes.
when you go for a job interview and you get offered a job,
Yes.
You can start on Monday.
Yes. There will unquestionably, we all know as a matter of common sense and from personal experience, that is a not uncommon situation. It happens. There are relatives and friends who can look after young children from time to time. But must recall that we're not saying here that it's impossible. It's a disproportionate
No,
impact.
I want to understand how it works. You then, if you're offered the job, you then have to presumably go about finding a place for the child.
Yes.
And assuming you find one, or simultaneously, I suppose you have to put in an application. Do you put in an application to get the childcare, or does the childcare costs supported by government, or does that come automatically as part of?
I understand it comes automatically, my lord.
Sorry.
I understand it comes automatically through the working tax credit system, but quite how
so the
efficient that is in
transitional
practice,
problem
I'm not sure.
is really finding the place.
Yes.
Yeah.
Now, there's a statement. I don't have the precise references to hand, but we can certainly look them up over the lunch break. I think it's Ellen Broom from the Child and Family Trust. not sure. We'll look it up. But she explains the practical difficulties that people have in exactly that situation that your lordship's got in mind.
The
We'll
difficulty
look that
that's
up.
identified is effectively a catch-22 situation. Is it which comes first,
Yes.
chicken and egg, or
Yes.
whatever? Yeah.
Yes.
Okay.
But we drill that down then by looking at the statistics and see what actually happens across the piece. Because plainly that will be successful for some people, but does it happen for? I'm being reminded by it is Ellen Broom's statement, which is in MS 5259. Yes, and it's particularly paragraphs 5 and 6.
Thank you very much.
And that deals with your lordship's point. Yes, we were coming to look at Mr. Ward's statement, if you recall, about the numbers who are capped, numbers in this category who are capped. I think we were looking at MS 9825. And we see here, under the heading, sorry, pick it up on the previous page, the heading Characteristics of the Benefit Cap Caseload as of February 2018. So this is a snapshot.
Which page are you on, please?
9824, my lord.
9824.
So I've just gone back to the heading.
Yes, I
to
see.
put it into context. So your lordship sees the heading Characteristics of the Cap Caseload.
Yes.
And then at paragraph 9, we see their reference to capped at the point of time, in this case, February 2018. And then over the page, this is the substance of the point. We've got the table. Percentage share of total capped households of lone parent cohort, all rounded to the nearest 100.
And the point has been made on the previous page that these figures are cumulative.
Yes.
Because otherwise one might get a little bit confused.
Yes. Yes, absolutely, yes. And the next point is that the lone parents by age of youngest child under 2, you'll see 14,300 as of February 2018, which is 24% of total capped households. Now we're going to come back to the significance of that when we're considering justification later in our submissions, but it's a very significant percentage of course. And it's precisely, I think, the sort of percentage one would expect, given the specific hurdles faced by this cohort of people affected. Now, we then come to the evidence of Mr. Harvey that we've just referred to. And if we can look at his second report, and that's in Appendix 3. This time we're going to MS 5459.
And for those of us who don't...
The internal, the internal page. 948 to 949.
Thank you.
This is Harvey 2. So it's his second report. We see paragraph 34. Can I invite the court to read paragraph 34 at page 948? And then we see the graph. He's put what he says in his text in the form of a graph on the following page. And having an open working tax credit claim, WTC, is being used as an indicator of being in work, as you can see. So the charts show that the likelihood of having an open working tax credit claim is lowest for lone parent households with children under 2. Now, I'm not sure if I think we've got colour versions of the graphs somewhere in the papers as well, but I think it's clear enough, I think, from the graphs we've got at page 949, I think. The lone parents are the darker columns.
The lone parents are the left-hand column.
Yes.
Couples are the right-hand columns.
Yes.
Yeah.
And that's exactly what one would expect.
Sorry, what would one expect?
Does your lordship have that?
I have the graph, which shows blue and orange.
Yes, so that's as you see immediately above the graph, percentage of households capped since April 2013 with an open working tax credit claim.
Yes.
So these are the percentages that have moved from the cap into work.
And for the ones age 2, that's the age of the youngest child we're talking about.
Yes. So what we see there is a very distinct pattern, that there's a smaller percentage of households with the youngest children who've gone into work.
And another interesting thing is that for couples, this difference is nothing like it.
No, not at all. Absolutely.
Not discernible at all.
Yes. Yes. And I think we know from our own personal experience, parents share the childcare responsibilities, and typically, I think we're entitled to take judicial notice of that.
Well, some of us are.
Most of us, it's grandchildren.
Well,
rather than
And of course, you've got to remember that these statistics only show the bare fact that some previously capped households have moved into work. It doesn't tell us anything about how difficult it was to do so. And as Lord Justice McComb said at paragraph 164 of his judgment, I'll just read the sentence. It's at MS 4569 for your note. The fact that people move off the cap does not seem to me, however, necessarily to justify their presence within it in the first place. So it only tells us so much. But nevertheless, there's clear and uncontested statistical evidence supporting the proposition that lone parents of children under 2 face particular barriers in entering work, which mean...
The difference is it, if you take 2 to 5, it's a difference of 28% to 42%, is that right?
I'm not sure off the top of my head.
Well, that's what they seem to be saying.
It looks as though once children reach school age, the difference disappears.
Yes.
well, it gets dramatically less.
The differences between single parents and couples reduces, clearly.
Yes.
Because you can see the 2 columns are much closer in height to each other than they are otherwise.
Well,
but I was just looking at the difference between a 2-year-old lone parent, or a lone parent with a 2-year-old, and a lone parent with a 3 or 4-year-old.
Yes.
And it goes 28, 31, 38. Is that, sorry, yes, 28, 31, 38, up to 42 when you get to 5. That's how it works, is it?
Sorry, your eyesight must be better than mine. I can't read these. It looks about right. Okay. I'll check that out with you.
We can also magnify it.
Yes. The point is, we're on significant difference, my lord, and whether it's 28%, 29%, or whatever, doesn't really matter. The point remains the same. That these people are in a significantly different position in finding work. Now, the response to that is that from the Secretary of State relies on general employment market statistics, and we see how Sir Patrick dealt with that in paragraphs 111 to 113 of his judgment below. If members of the court have still got that to hand, that's MS 4551 to 4552. particularly paragraph 111. And again, can I invite the court to read that paragraph?
Sorry, can you give
MS 4551, my lady.
4551?
Yes.
4, 5.
Full volume, page 40. Lord Wilson.
Yeah.
So we see about 2/3 of the way down this paragraph that Sir Patrick says these statistics are consistent with the proposition that it is easier for lone parents to move into employment as the youngest child gets older, as in parentheses, as one would expect. But they are not consistent with the conclusion that it is either extremely difficult, far less impossible for parents with children under 2 to obtain employment. But of course, that's never our case. We've never said that certainly haven't never said it's impossible. We say it's difficult. Whether it's extremely difficult is a matter of terminology. But although on their face these general statistics referred to by Sir Patrick, and of course the President agreed with this analysis, show that there's a proportion of lone parents with children can and do work, they are fundamentally unsuitable as evidence of this Thlimenos issue. And that's for a number of reasons. And that's because they're reliant on the household annual population survey, which includes households that don't receive benefits, and households that can afford to pay for childcare privately. And as we see from Miss Garnham's second statement, I don't know if members of the court have got this. It came in late from CPAG. Loosely, it's not in the bundles.
It's in the electronic bundles.
Is it? Right. Sorry, it's not in mine.
It is, isn't it?
Not the second, I don't think, my
Not
lady.
the second, sorry.
The second one did come separately. Yeah.
The striking point that comes out of this,
Where it is.
page 4 of this statement. I don't need to introduce Miss Garden. The members of the court know that she's the chief executive of CPAC and so forth. I take it. Miss Garden makes this statement in response to Mr. Ward's statement. Can I invite the court to read paragraph 12A? And so what it appears to be saying there is that the statistics that are being relied on include people who work for as little as 1 hour a week. And in any event, as we know from Mr. Ward's statement, who refers to these Office of National Statistics, this is at MS 9831 in the additional volume 1 of 2. What we learn from Mr. Richard Ward is that the ONS The youngest lone parent cohort in respect of which the ONS prepares employment statistics is lone parents with children aged 0 to 2, which includes 2-year-olds.
This is paragraph
28, sorry, my lord.
28, sorry.
So that doesn't really give us much help with respect to identifying the position of this cohort of people affected by the cap.
Can I ask, Mr. Wise, if you could clarify one matter for me, not necessarily now, but perhaps after the adjournment?
Yes.
It's just looking at the chart of Mr. Harvey's we looked at a moment ago.
Yeah. Can you just remind me which page it is?
It was on page 949 of
949
of Appendix 3 and MS 5459, I think.
Yes, got it. Yes.
All I was wondering was, it tells you the percentage of households capped were told since April 2013 with an open WTC claim at November 2016 by age of youngest child.
Yes.
I'm wondering, is that the age as at November 2016 when they had the open claim, or is it at some earlier time? It's a little bit, it's not quite clear. I mean, for example, 0, the babies category, obviously if a child was a baby in November 2016, it wasn't necessarily born at the time of a capping. So
I wouldn't like to speculate, my lord. I don't know, frankly, off the
Right.
top of my head. I will get back to you at 2 o'clock if at all possible.
Yes, thank you very much.
And so the point we were making was that the statistics relied on by the Secretary of State from the annual household population survey don't really assist, because they are not directed at this cohort and don't deal with the problems that we're concerned with. In response, the Secretary of State says in her written case, at paragraph 993, that there is no difference in the ability of lone parents with children under the age of 2 to find work which is significant enough to engage the Thlimenos principle. That's the way the Secretary of State approaches it. 2 points in response to that. Firstly, there's a suggestion there that there's some kind of arithmetical hurdle that needs to be overcome to establish significant difference. It's not said what that hurdle is, and indeed there's nothing to support the proposition that there needs to be a significant enough hurdle to engage the Thlimenos principle. And as we've already said, there is anyway, in any event, plainly a significant difference as recognised below. So, in summary on this point, we say that the judge's first instance was correct, having looked at this raft of material. Paragraphs 23 to 28 of Mr. Justice Collins's judgment, where he made the finding that he did that the groups within which we are concerned are in a significantly different position. And we say that Lord Justice McComb was correct, therefore not to interfere with his judgment in this regard. And you'll see the reference in Lord Justice McComb's judgment to the Smet Properties case. We've got that in the authorities bundles, and what Lord Justice Sales said about the role of appellate courts, but I don't need to tell members of this court the caution that the appellate courts are required to have where the court below or a trial court has heard and considered the evidence. We've been concerned primarily over the last few minutes with the position of the parents. It's important not to lose sight of the fact that the children under 2 themselves are also a discrete Thlimenos category. This is partly, we say that they are a discrete category, they are significantly different, partly because of the difficulties their parents face in escaping the cap, but it's also critical importance that they are severely affected themselves as individuals. There was uncontested evidence in the courts below on this, referred to by both the High Court and the Court of Appeal. It's particularly the evidence of Professors Bradshaw and Atkinson. If we can look at Professor Bradshaw first, again that's in Appendix 3, MS 5128, page 617. Yeah, it's the first appendix 3. If we can look, before we come to the relevant paragraph, if we can pick it up at the beginning of the statement at 5126, paper number 615, sets out who Professor Bradshaw is, Emeritus Professor of Social Policy at York University, specialist in child poverty, social security policy, worked in the field for almost 50 years, and then sets out his CBE for services to child poverty, etc., over the page. And then we see at the second page of his statement, 5127, 616 of the paper version, the heading Poverty and the Impact on Children General. And we see a reference there to the 60% figure that I think came to light yesterday. But if we can pick it up at paragraph 5, page 5128, the well-being of children is affected if they are poor, and most domains of child well-being are affected by poverty or its proxies. There is a vast literature on the impact of poverty on outcomes, which have been reviewed by Griggs and Walker. Their review covered in particular at A, the court will see under health, the impact of poverty on health during the antenatal period, birth and infancy in the first 2 years of life is profound. And again, that comes back to the instinctive point we made earlier. I think we generally recognise, but that's generally recognised. But this is Emeritus Professor, reviewed all the literature and says what he says there. That's uncontested. And again, marks this cohort out as being different. And particularly, as I say, at the moment, with respect to the children. We've also got the statement, I think it is, of Professor Maggie Atkinson, who was the former Children's Commissioner. I don't need to take the court to it, but the references are MS 5116 in the second volume of the DA claim, the appellant's appendix, particularly paragraphs 68 to 70 at page 605. So in summary, we say that the children under 2 are also significantly different from other children affected by the cap, such to engage the Thlimenos type discrimination. I've dealt there with the first of the 4 issues that I said at the outset that I was going to deal with. The second issue is that of justification. And as we say, particularly the weight to be attached to the considerations by Parliament. But before we come to that, there is of course a number of discrete points that are of concern. There's no controversy in this case concerning the application of the well-known 4-stage test for justification. I think that's generally now accepted. The controversy here is over the standard to be applied to the court in the last of those 4 stages, namely when coming to consider whether there's been a fair balance struck between the rights of the individual and the community. We've set out in our case why we contend that at this stage, the manifestly without reasonable foundation test is inapt, and the correct approach is for the court to make its own decision. Particularly rely on what my Lord Wilson said in the A case at paragraph 33. But we've set that out and all the references in our written case at paragraphs 122 to 123, MS 8265 to 8267. And the point's a straightforward one, and doesn't require any elaboration. If I can invite the court to read those paragraphs in due course. But regardless of which approach is adopted by the court, whether it's manifestly without reasonable foundation or otherwise, the court will nevertheless afford a degree of respect to the decision maker. That applies whether we're correct about the manifestly without reasonable foundation test or not. But the question then arises as to what latitude or respect is provided to the executive who promulgated the regulations in this case. And two discrete issues arise here. Firstly, the importance or otherwise of the parliamentary debates that the Secretary of State has placed considerable emphasis on. And secondly, the potential for the courts to undermine the will of Parliament by emasculating the benefit cap scheme, the word that we saw used on a number of occasions in SG. So we can take both of those issues head on if we can. Firstly, the importance or relevance or the importance or otherwise of the parliamentary debates. The Secretary of State relies heavily on parliamentary debates, which she says in her case at paragraph 63 are relevant to, in quotes, inform the court as to the background, rationale and potential impact of the benefit cap and draw the court's attention to the fact that a series of amendments were considered and rejected. We need to consider what the role of what the importance of these debates are to the justification exercise when conducted by this court. Well, we're clearly not in pepper and heart territory. We're not trying to elucidate the meaning of legislation. That's not what we're concerned with. What we're concerned with is how it assists in the justification exercise where convention rights are at play. And the lead case on that is, of course, Wilson and First County Trust, which bears rereading. It's in volume 10 of the authorities bundle, starts at MS 3568, if we can just turn that up. It's tab 88 in volume 10 for those using the paper materials. The court will no doubt recall the basic facts of Wilson First County Trust, the consumer credit provisions and whether they breached the convention. We're not concerned with the facts of the case. It's the principles that we get out of it. There isn't one lead judgment in this case. We turn for simplicity to the judgment of Lord Hobhouse, whose judgments and the passage starting particularly at paragraph 139, which is MS 3616. Just before we go to that, just to explain the dynamics of the court, Lord Nichols made comments to similar effect to the ones that I'm going to take the court to, paragraph 61 to 67. Lord Hope to similar effect at 116 to 18. Lord Scott agreed with Lord Nichols and Lord Roger agreed with Lord Hobhouse. So there's a general consensus, although it's expressed in slightly different ways in the different judgments. But Lord Hobhouse puts it as as pithily and to the point as more pithily and more to the point, shall I say, than his colleagues. So if you can pick it up at paragraph 139, you'll see the Pepper and Hart debate, which was very live, of course, at that time. And we'll see that Mr. Sumption was in the case. I don't recall who he was for, but anyway, if we see between G and H, Mr. Sumption pointed out in his submissions, it's a fundamental error of principle to confuse what a minister or a parliamentarian may have said or said he intended with the will and intention of Parliament itself. So that there's a note of caution when reading that so-and-so said such and such on such and such a day. What one has to put that very much in context, and with respect, we would say that Mr. Sumption was absolutely correct there. If we turn over the page, MS 3617, paragraph 140, again, Mr. Sumption did reference to Mr. Sumption's submissions. He didn't seek to challenge the authority of Pepper and Hart, nor did he found upon any argument of breach of parliamentary privilege. He found on two criticisms of the Court of Appeal's approach to the parliamentary material and the use they made of it. He criticised the confusion of the intent of individual members of Parliament with the intention of Parliament. And Lord Harpower said he was quite right to do so, and I need nothing more, to add nothing to what I have already said. And then
I think Lord Hobhouse was expressing an intensely personal view in this paragraph, wasn't he? He says that the affairs of those pessimists.
Oh yes, certainly on that respect, yes, with that respect, and that remains a live debate, of course. But we're not concerned with Pepper and Hart, but we are concerned with the utility of Hansard reports. I mean, we've got copious Hansard reports in this case, and we've got a whole file of them somewhere buried in the papers. I noticed the time. I was going to take the court to paragraphs 141, 142, and 144, but we can perhaps pick that up.
They're on the point that you're
Precisely.
to make,
That
having
was what
cleared out of the way the Pepper and Hart point.
Precisely,
so,
yes.
Let's adjourn there
yes.
and hear from you further at 2 o'clock.